The clerk will designate the amendment.
Amendment number 8, printed in Part A of House Report number 114-326, offered by Mr. Denham of California.
Pursuant to House Resolution 512, the gentleman from California, Mr. Denham, and a member opposed. Each will control 5 minutes. The chair recognizes the gentleman from California for 5 minutes.
Thank you, Mr. Chairman. In 1994, Congress enacted the Federal Aviation Administration Authorization Act, or F4A, to prevent states from undermining federal deregulation of interstate commerce through a patchwork of state regulations. Since 1994, motor carriers have been operating under the federal meal and rest break standards until a ruling by the California Ninth Circuit Court. This amendment would remedy that issue, and I would reserve the balance of my time.
The gentleman reserves. For what purpose does the gentleman from Oregon rise?
Rise in opposition.
The gentleman is
Claim
recognized.
time in opposition. Yield myself such time as I may consume. Unfortunately, the language of this amendment is so broad that it would basically preempt, meal, rest break, and other laws that relate to truck drivers in 21 states. So I think, this is an issue of states' rights, and it's an issue of an overly broad attempt to address what is a real contradiction that was created by the Ninth Circuit. If you have a truck driver who's operating long haul through a number of states, having to comply with new rest or meal break requirements and the federal clock, which I can barely understand with the new requirements on rest. Every time the driver crosses a state line, it's confusing and I think is a potential impediment to interstate commerce. And we offered an amendment that would have specifically addressed that concern. Unfortunately, we weren't able to reach agreement on that. Mr. Larson from Washington State submitted that amendment to the Rules Committee. It was not allowed, and unfortunately, we are only have this overly broad amendment. So this would not just affect interstate trucking, it would preempt California's wage, hour, and rest break rules for intra-state trucking in the state of California and 20 other states. In fact, the case that was before the Ninth Circuit was intrastate truck drivers who are delivering appliances. And it also would go further. I mean, we spent a lot of time when I chaired the subcommittee on the issue of these basically pressed labor who were theoretically purchasing their trucks, their drayage trucks, to haul a cargo out of Long Beach and out of Los Angeles, who were really basically being enslaved. They were never going to pay them off. They're never going to own them. In fact, they were hot-seated, that other people were also buying the same truck at different hours of the day. Nobody ever got the trucks. This would basically preempt any laws in California so that drivers could be paid on a piece rate, no matter what the congestion conditions. Sorry, gee, we paid you for that load, so it took you 8 hours. That's the way it is. So you only earned 49 cents an hour. Sorry, because wage and hour laws don't apply to you. So it is just overly broad attempt to address what is, what does have at its core a contradiction under the F4AAA or whatever it is that they call the ruling about interstate commerce. So we would have to oppose the amendment. With that, I reserve the balance of my time.
The gentleman in reserves. The gentleman from California is recognized.
Thank you. And I think the gentleman from Oregon, he was here in 1994 when Speaker Foley pushed this issue through. He understands the issue, and while his language did not fully address the issue, we're going to continue to work together to resolve this as this amendment moves forward. I'd now like to yield 1 minute to Ms. Brown from Florida. Yield was the word I was looking for.
Thank you.
The gentlelady from Florida is
Thank you.
minute.
Let me just say first, Mr. Schuster, Mr. Fabio, I want to thank you all for your leadership in getting this bill to the floor. And I'm just going with the new speaker who said the will of the House. And I'm sure the will of the House will pass this amendment. And why? Because one of the things, transportation is intermodal. And I was here in 1994. We said we're not going to have a patchwork. We're not going to have each state with their own rules and regulations. I say let's move forward. And this amendment, in my opinion, we need to reinstate the intentions of the Congress in 1994. And with that, I'll yield back the balance of my time.
The gentlewoman yields back. The gentleman from California is recognized.
Reserve.
The gentleman
Reserve
from
balance.
California reserves. The gentleman from Oregon is recognized.
I deal myself such times I may consume. I would note that 90% of the trucking industry is represented, not necessarily in terms of volume, but by the OIDA, I mean in terms of value, by OIDA, and they are opposed to this. And with that, I would yield a minute to the gentlelady from California, Ms. Napolitano.
The gentlewoman from California has 1 minute.
Thank you, Mr. Chairman. I thank Mr. DeFazio for yielding. I rise in opposition to this amendment, which would overturn a federal court decision that determined California meal and rest breaks law apply to truckers. On July 9th of last year, the 9th U.S. Circuit Court of Appeals, that was mentioned before, ruled that trucking operators in California must allow 30-minute breaks after 5 hours of work and a 10-minute rest break after each 4 hours worked. The meal and rest break standard is very reasonable when you consider the truck drivers can be subject to 14 hours of on-duty time. The amendment would not only preempt California's law with regard to trucking operations, would preempt 21 other states' laws currently in force in territories that guarantee a state break. And I won't go into the states' names, but the states must not be allowed to set meal and rest break standards. It should be allowed, rather. They must be allowed as they see fit for the health and safety of their workers. One size does not fit all. Mr. Chairman, I ask my colleagues to oppose, and I yield back.
The gentlewoman yields back. The gentleman from California is recognized.
Yield 1 minute to the gentleman from Pennsylvania, Mr. Costello.
Thank you, Mr.
The
Speaker.
gentleman from Pennsylvania is recognized for 1 minute.
Thank you, Mr. Speaker. This amendment is needed to keep interstate commerce moving and to correct a misguided ruling issued by the Ninth Circuit Court of Appeals. Here we're faced with an overactive judiciary legislating from the bench with very real and very adverse economic consequences as a result of this misinformed decision. Mr. Speaker, Congress has taken deliberate action in the past to preempt states from getting in the way of a national uniform set of rules for motor carriers, and this amendment makes clear the intent of Congress that states can't impose their own requirements on drivers whose working hours and breaks are governed under nationally uniform federal regulations. Mr. Speaker, under current federal safety regulations, drivers who need a break are always entitled to take one. This amendment does not change that. Likewise, current federal whistleblower laws protect drivers from carriers who stand in the way of that, and this amendment does not change that. But as a result of the Ninth Circuit Court decision, motor carriers will now be forced to plan their routes and services around the obligations of individual state break requirements. This will deprive businesses and drivers of the flexibility currently afforded under federal law for interstate commerce. It will reduce shipping capacity, it will increase shipping costs, and it causes confusion and cost. If not corrected, who will pay the price for the decision of the unelected judges of the Ninth Circuit? In my district, the small businesses, consumers who face higher prices, and it will prove more costly to transportation professionals whose livelihood is directly dependent on an efficient and streamlined shipping and trucking
Gentleman's time has
industry.
expired.
I yield back.
The gentleman yields. The
Reserve
gentleman
balance.
from California is recognized.
Reserve the balance of my time.
The gentleman from California reserves. The gentleman from Oregon.
Time remaining?
45 seconds to the
On-
gentleman from Oregon.
I have 45 seconds.
Yeah, 45 seconds.
Okay. Yield to the gentleman 45 seconds.
Okay. Mr. Chairman, I stand in strong opposition to this amendment. My friends across the aisle regularly reject legislation because it encroaches on states' rights. Yet their commitment to state sovereignty disappears when it comes to protecting workers. This amendment does more than just clarify the Federal Aviation Administration Authorization Act of 1994. It changes and expands its application to preempt the will of states such as mine. California's meal and rest break laws ensure a safe working environment for truck drivers traveling within the state, and the U.S. Court of Appeals specifically ruled that these laws are not preempted by the Federal Aviation Administration Authorization Act. This amendment overrules the court and state legislatures to weaken labor protections at the industry's request. As a member of the Education and Workforce Committee and as a Californian, I stand in strong opposition to this amendment and urge my colleagues to vote against it. I yield back my time.
The gentleman yields back. The gentleman from California is recognized.
Mr. Speaker, would request to know how much time is remaining.
The gentleman has 2.5 minutes.
At this time, I'd like to yield 1 minute to the gentleman from Nebraska, Mr. Ashford.
The gentleman from Nebraska is recognized for 1 minute.
Speaker, and I'm proud today to stand with Representative Denham as a co-sponsor of this amendment. This amendment reinforces, make no mistake about it, current law that has been on the books for over 2 decades. It promotes interstate commerce, ensures continued economic growth, and fortifies safety requirements. This amendment will allow a vital industry in my district and a vital industry to our nation, the trucking industry to operate without a patchwork of state regulations. In my home state of Nebraska, we have several of the nation's largest motor carriers. These employers haul freight throughout the country and provide good-paying jobs. Unfortunately, these employers may now face litigation that could cost tens of millions of dollars and create regulatory uncertainty across this country. Far-flung litigation shouldn't threaten the livelihood of hard-working Nebraskans. It is likely that companies like those in my district will simply refuse to do business in certain states. This result will destroy jobs, hinder competition, and hurt taxpayers. I encourage my colleagues to support this amendment. I yield back.
The gentleman yields back. The gentleman from California is recognized.
At this time, I'd like to yield 45 seconds to the gentleman from North Carolina, Mr. Walker.
The gentleman from North Carolina is recognized for 45 seconds.
Clear that the patchwork of laws and rules dictating when drivers eat, sleep, and pull over is impractical. 50 standards creates an unreasonable burden on truck drivers and companies. Furthermore, dismantling the federal standards jeopardizes safety and increases costs, causes insignificant inefficiencies, reductions of competition, inhibits innovation and technology, and curtails the expansion of markets. I support the Denham Amendment and encourage my colleagues to do the same. Thank you, Mr. Speaker. Yield back.
The gentleman yields back. The gentleman from California is recognized.
Reserve the balance of my time.
The gentleman has the only time remaining.
Yield the balance of my time to Mr. Stewart.
Yes, thank you.
The gentleman is recognized.
Mr. Chairman, I rise in support of this amendment. In my district, I have some of the largest trucking companies in the country. I recognize that these are hardworking, dedicated people who play a vital role in the success of our economy. And the growth of regulations under this administration have made their jobs much, much more difficult. This amendment seeks to relieve truck drivers of a patchwork of regulations that make their jobs very difficult and to little positive effect. And let me correct a common misunderstanding. This amendment does not prevent drivers from taking breaks when they think it's appropriate. In fact, it does the exact opposite. It allows the drivers to be flexible, to take breaks when they think it's most appropriate and most safe, and not to worry if they are violating the law. Arbitrarily predetermined break times set by 50 different states simply will not work. And that's why I'm such a strong supporter of this amendment. And with that, Mr. Chairman, I yield back.
The gentleman's time has expired. The questions on the amendment offered by the gentleman from California, those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the noes have it.
Requesting recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from California will be postponed.